Alex here with part 38 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. My ex's parental rights have been terminated. Number two, the nutshell version as to the point of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in part 37 with the reply to my ex's opposition to have her ordered to turn over the medical benefits cards. At this point in the process, we will be taking a look at the court's order, and I would like to state immediately that we don't even have to go to a hearing, which is apparently very different from what a lot of other people have to go through anytime a paper is filed. Most of the time, and especially in more urban areas, the people who are parties to those types of cases have to go before the court and see the judge face to face. The rest of us, especially those who are in more rural districts, will usually only have to go and see the judge when it's deemed necessary by the judge. There are some situations where a judge will enter a summary order, which means they won't even bother taking evidence. They will make a decision based on the allegations alone. And sometimes it's because there are no genuine issues of material fact that are relevant to, be discovered by the court. And other times it's just because whatever particular bit of evidence or fact that is actually relevant has been admitted to. It's like not in dispute by the parties. Both sides are in agreement about a particular thing that has occurred, and they just have different opinions as to what the court should do. My mindset at the time was pretty bad. I mostly was afraid of having to pay attorney fees, and I talk about this problem in the video Defend Against Attorney Fees. I think I did a pretty good job on reply countering my ex's request for attorney fees, but at the time I didn't know that attorneys routinely ask for that stuff. I thought that my ex's attorney thought she could win that particular award of attorney fees. I was already so poor that I couldn't afford my own attorney, and the thought of having to pay for my ex's attorney when I couldn't even afford my own made me sick to my stomach. I lost sleep, I was anxious about it, and all of that would end quite swiftly and dramatically almost. I mean, that's my feeling when I read the order from the judge was, wow. It was, at the time, the biggest win I had ever seen representing myself, especially considering the fact that I was going up against an attorney. And I think at this point, all that having been said, why don't we go ahead and take a look at what our judge has filed. Here we have the judge's order. That's all he titled it. He did not want to have to go and type out that huge title that I and my ex were pretty much going back and forth with during the briefing. He just called it order, which is fine, because that's what it is. The first paragraph is the summary. As you've seen on many occasions, he identifies who I am. He identifies my ex and the fact that she filed an opposition. He also recognizes the fact that I filed a reply, and this is him summarizing the briefs and the fact that he has considered those 3 documents, the motion, the opposition, and the reply, and having considered them, now enters his order. The next paragraph is a brief summary of the facts. He mentions that our son was born a specific year, date. He mentions that pursuant to the final order in this case, which happens to be the order after hearing entered May 26th, we share joint legal and joint physical custody, and he mentions that my ex was ordered to provide medical insurance for our son. We agreed to provide all information necessary to facilitate the submission of a claim, and additionally, we were both ordered to utilize in-network healthcare providers. So He mentions this is typically what he does with every single order he enters. He first summarizes my request, and he mentions that I filed a motion asking for the court to order my ex to provide all of that information pertaining to my son's medical, dental, and vision care providers. He also recognizes the fact that I am asking for a no contact order and for my ex to disclose her address. What's his piece here? What is he saying? He's recognizing that I am asserting that I do not have the information I need and that my ex has attempted to provoke physical and verbal altercations at exchange points. Let's move on. Oh, wait. That last sentence there. I'm asking that she needs to provide me her address for emergency purposes. Yeah, it's true that I asked for it based on that purpose, but as we all know now, pursuant to Falcone v. Secretary of State, which was published in 2013, parents are entitled to know where their children reside. So you don't really have to use that argument or that assertion that you need your ex's address for emergency purpose. You're just flat out entitled to know where they reside, with rare exceptions. Next paragraph, he summarizes my ex's opposition. He states that he is recognizing that she is alleging or stating that she's provided me with all the necessary information. He's summarizing that she is indicating that I don't need her personal information and that I can easily attain regular or emergency care. And he also notes that she agrees to the no contact order. Looks like she's requesting to keep her address from me and that we can just maintain contact. Well, he's actually saying in a very one-sided way, because she said in her opposition that she was willing to just not have either of us know where each other lives, but he's only bringing up the point here, arguing that, or she is arguing that, or at least he says she's arguing that I'm the only one that doesn't need to know where she resides. I guess it's not really a big deal to point it out since she does know where I live, so this is really the only address that's in question here. But I'm surprised they didn't take advantage and make it more of a reciprocal thing at that point. She's asking for attorney fees, so he points that out as well. He is summarizing my reply, which is that I'm reiterating my original arguments, which is true. You shouldn't do that. He is saying that in a way as to insinuate that I wasn't really supposed to do that, and that's true. I talk about that in my video, Replies to Oppositions to Motion. You're supposed to identify the new issues that your opponent has raised in their opposition, and those are the issues that you're supposed to controvert on reply. You're not supposed to take all the stuff you've already said in your motion and just repeat it again on reply. So try not to do that. He's pointing out that I am acknowledging she's complied with noticing me as to having provided health coverage, but I'm asking more specific orders as to how we should cooperate in his healthcare. Indicates that I am agreeing to the fact that she stipulates on no contact, and I am still arguing that I am entitled to know where she resides. All of these bases that I'm providing, that she's exhibited behavior that's inconsistent with the alleged fear, etc., all that stuff you don't need to really bring that up, because, as I mentioned, Falcone v. Secretary of State makes it clear that just by virtue of having a child with them and sharing custody, you're entitled to know where they reside. You don't need any kind of additional basis to know where they reside. And the last piece here is that I am arguing against an award of attorney fees, and I am stating that I did attempt to resolve the current dispute with her prior to filing a motion in this matter. I believe I did talk about this before. This is actually a court rule in the 8th Judicial District Court, but it is not anywhere else in Nevada. In the 8th Judicial District Court, there is a rule that mandates that you try to work something out before filing a motion, and then if you do not do that, you will be subjected to an award of attorney fees. Well, you will have an award of attorney fees imposed on you in favor of your opponent. And in 2nd Judicial District Court, there was no rule stating as such, so you didn't have to do that. But as I mentioned, even though I didn't have to do that under the rules, it's a very good habit to get into. So even if you're in a jurisdiction that won't punish you for not doing that, you still should do that, because you're going to be dealing with attorneys who argue that you're annoying, that you're harassing everyone, that you're vexatious, and that because of all those things, you need to pay for attorney fees. So one of the things that you could use sort of as a shield against those allegations is email communications indicating that you're here in court as a last resort. You tried to work it out and it just didn't get worked out. Next paragraph here. The court recognizes the fact that we are both joint legal custodians, and one implication of that designation is that we are each obligated to inform the other about all medical attention our son requires. The parties are required, except in an emergency, to consult together before setting appointments and obtaining medical treatment. And Each of us is entitled to know in advance the name and address of any healthcare provider and the dates and times of any appointments. The brief description does not detail every duty that we have, and we are entitled to know everything about our children's medical needs and concerns. Joint custodians have a legal obligation to share the information in advance of treatment, except in emergencies. Next paragraph. The court recognizes that my ex is contending that she can make no insurance card available to me and that her signature is required each time our son needs non-emergency medical care. The court has never before encountered such restrictive requirements. Mother is ordered to provide me with an insurance card within 10 days from the date of this order that will allow me to obtain medical attention for our son without her signature. Alternatively, she is ordered to set a hearing within 10 days to occur within 45 days from the date of this order. And if a hearing is required, she is ordered to arrange that an insurance company representative appear telephonically at the hearing to explain the unusual limitations that my ex is describing. She is also ordered to provide me with the contact information for that witness at least 10 days in advance of the hearing so that I can converse with that representative prior to the hearing. He is pissed. And let's continue on here. Pursuant to our agreement, the following no contact order is entered, and he basically orders what I asked for. We're not allowed to go to each other's home and place of employment, and there shall be no communication between us except communication regarding our son's welfare. And last but not least, the exchanges shall occur in the entryway of the Denny's restaurant. This was a big win because no longer from this point on did she follow me all the way to my car, stand behind me, and peek over my shoulder. That was the end of that. So it was good for me to get this order entered so that I could get that at least taken care of. Not only her, but whatever random person she happened to bring with her at the time. As a general rule, we are entitled to know where our child or children, in this case we just have one, resides. And the law provides an alternative only when a person is a victim of domestic violence. So he is citing the statute, he is citing Nevada's confidential address program, and he is going to order my ex to do one of two things. Let's go ahead and scroll down here. He is going to order her to, within 30 days from the date of this order, give me her actual address or give me a fictitious address from the confidential address program. Now, as all of you know, especially those of you who've been following the channel very closely, she chooses to give me the fake address from the confidential address program, which leads to a massive lawsuit against the Secretary of State. And I did ultimately win that and trigger a publication that opened the doorway for all other parents after me to use a procedure to challenge a so-called victim's confidential address program fictitious address. And we're going to talk about this a whole lot more when we actually get to the part of the My Docket series where I sue the government. But at this point in time, we are not there yet, and I'm going to get into a whole lot more detail at that time. It's quite a long and drawn out tale. But I will take each of you, all of my viewers, I will take you all through that process step by step, video by video. I imagine it's going to be at least 15 videos to go through the entire lawsuit against the Secretary of State. But at the end of that road, there was a victory. And I'm pretty eager to talk about that, but I need to hold off because we're just not at that point yet. So, almost forgot there. He spends one sentence, a total of 7 words, on her request for attorney fees. And I quote verbatim, "Mother's request for attorney's fees is denied," unquote. We're going to go ahead now and see the next page, which is the certificate of mailing. The judge's administrative assistant is indicating that he or she, I can't tell based on that signature, has mailed this document to both myself and my ex. And you can see here that he is citing Rule 5. Rule 5 is the rule that I've talked about before that allows a litigant or the judge, the court, to serve somebody through the mail. The judge has disposed of my motion to have my ex ordered to turn over that documentation, provide her address, and for the no contact order. By granting that motion, we are going to go ahead and go into the aftermath now. I didn't file anything, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney could have spent many hours on this, but we just don't know. I'm inclined to think that my ex, when she was confronted with this order from the court, that she probably wanted to get an insurance agent on the phone. She probably wanted to set a hearing and hash it out in court. And there was probably a lot of back and forth between her and her attorney on this. Several hours worth, probably, potentially 5-6 hours worth. But we don't know. And I'm going to err on the conservative side, as I've done throughout this entire series, and I'm going to say half an hour for my ex's attorney to communicate with my ex about this order. We're going to assume that she just caved and decided to turn over the medical benefits cards, which she did. And the address, of course, as I mentioned earlier, she decided to go ahead and get the fictitious address from the confidential address program. So 30 minutes, I think, is reasonable. It's the conservative end of the guess. And at the rate of $250 an hour, that comes to $125 in attorney fees. If anyone has any questions, feel free to post something down in the comments below. And I will see you guys next time.